Hi everyone, I am Safi and I am here to discuss about intellectual property rights. Introduction. Intellectual property rights are often the most valuable assets owned, used and developed by a software house. Intellectual property rights include confidential information, patents, trademarks, designs, copyrights protecting program. They protect information stored by electronic means and all of the paperwork which accompanies a program such as the user manual plus any multimedia packages and most items on the web. Great care should be taken to protect, exploit and enforce intellectual property. The name under which a product is sold may be registered as a trademark. The hardware or a process used in its manufacture may be protected by a patent. The look of the product may be registered in the design registry. Software can be protected by copyright. The know-how which goes into the development of the product may be protected as confidential information. Unauthorized use of intellectual property can be stopped by injunction and damages may be sought for infringement of these rights. The law is constantly changing with technological advance. General Agreement of Tariffs and Trades (GATT) concerned the protection of intellectual property rights in the face of widespread piracy of software products. What is confidential information? Information which is not publicly property and public knowledge. Any category of information from personal confidences to trade secrets and sensitive government information, any or all of which a computer scientist might handle in the course of his work, of his or work, or all, or any of which a firm may want to protect against unauthorized use of disclosure by others. Information will be protected only if it is confidential. Non-confidential information, unless protected by copyright or a patent, is deemed to be in the public domain and can be used anyone. Three conditions must be satisfied before an action for breach of confidence can succeed. The information must be confidential. The information must have been disclosed in circumstances which give rise to an obligation of confidence. There must be an actual or anticipated unauthorized use or disclosure of the information. These these three conditions are very important for the exam point of view. So keep in mind. What are patents? A government authority conferring a right, a title for a set period, especially the sole right to exclude others from making, using, or selling an invention. A patent gives to an inventor a monopoly in an invention. This means that the inventor is giving the exclusive rights to use or exploit the invention for a defined period. The monopoly granted by patent law is so strong that the owner of a patent may even exclude independent inventors from the market. The better the patent, and the more commercially desirable the breakthrough, the more likely it is to be challenged. For example, if competitors can produce similar products or process which is not covered by the patent, they will be free to market it and to erode the commercial advantages of the patent. If they can prove that the subject matter of the patent has been used or disclosed before, they can invalidate the patent. Patent Act merely sets out a number of criteria which must be satisfied before an invention can be patented. A patent may only be granted if the invention is new, it involves an inventive step, it is capable of industrial application, the subject matter of the invention does not fall within an excluded clause. It is possible to patent something which is more than just a program, something which can be called for simplicity a program plus computer program is not excluded from patentability if it produced or is capable of producing a further technical effect beyond the normal physical interaction between software and hardware. It is potentially patentable if it makes something else to do something. What are copyright? The exclusive legal right given to an originator or an assignee to print, publish, perform material, and to authorize others to do the same. Copyright protects more items generated by businesses or by individuals than any other aspect of intellectual property law. It can protect business letters, manuals, diagrams, computer programs. Copyright owners face the specter of unlimited piracy through uncontrolled copying with the advent of internet. What we will probably see over the next few years are stronger laws, more rights of for copyright owners, widespread listening, licensing schemes, and greater use of technical anti-piracy or copy monitoring devices and electronic rights management systems. Copyright law gives six exclusive rights to the owner of the copyright. It is the most important short question in this slide. Copyright law gives six exclusive rights to the owner of the copyright. First one is copy the work. Second one is issues copy to the public, rent or lend the work to the public, perform, play or show the work in public, broadcast the work or include it uh, in a in a cable programmed service, make an adaptation of the work or to do any of the above with an adaptation. The rights apply equally to published and to unpublished works. Acts permitted in relation to copyright. Some acts are permitted under the Act 1988, even though they would otherwise amount to breach of copyright. First one is fair dealing, making backup copies of computer programs, transfer of works in electronic form, decompilation for the purpose of intero interoperability, error correction databases, remedies for breach of copyright. A copyright owner has all the usual civil remedies of such injunction, damages, and an action for an account of profits made in breach of copyright. If it is shown that at the time of the infringement of copyright, the defendant did not know and had no reason to believe that copyright succeeded in the work, then the plaintiff is not entitled to damages against the defendant. A copyright owner is also given an important power to enter premises without using forces in order to seize infringing copies or articles specifically designed or adapted for making copies. What is plagiarism? The practice of taking someone else's work or ideas and passing them off as one's own. All of the following are considered plagiarism. Turning in someone else's work as your own, copyright words or ideas from someone else without giving credit, failing to put a quotation in quotation marks, giving incorrect information about the source of a quotation, changing words by copying the sentence structure of a source without giving credit for a computer program, changing variable names only or not changing the structure of the flow of the program. Thank you very much, guys.